This lecture will be devoted to Francis Coralie vs. Union Territory of Delhi, a leading and outstanding landmark judgment of Supreme Court delivered in 1981, and this judgment revolves around conservation of foreign exchange and prevention of smuggling activities Act 1974, where the petitioners under Habeas Corpus petition filed as per the provisions of Article 32 of the Fundamental Rights challenge Section 3 of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974 as it was violating Article 14 right to equality and Article 21 right to life and personal liberty as guaranteed under Part 3 of the Fundamental Rights of the Constitution. Also, the petitioner challenged Article 22 regarding arrest and preventive detention. So, the Constitution of India upholds fundamental rights, which are the fundamental human rights that shield all citizens from governmental intrusion. The Indian Constitution's third part addresses fundamental rights. These are those rights that the Constitution specifically guarantees of the citizens and even of some non-citizens. However, some rights were set by decisions made by judges. So, here we would like to discuss some existing laws such as the Coffee Act could not be violated those fundamental rights. So, we would like to discuss the very facts relating to this landmark judgment. So, here, Francis Coralie's detention under the Conservation of Foreign Exchange Prevention of Smuggling Activities Act 1974, a writ petition was filed under Article 32 of the Constitution of India and challenging under Section 3 of the Coffee Act, the petitioner, a British national, was being held in Central Jail, that is the hard jail. She requested a writ of habeas corpus under Article 32 from the court to contest her detention, but her plea was denied. She had trouble getting in touch with her attorney and family while she was being held, especially her little daughter, who she was only permitted to see once a month in accordance with Section 3, subsection B, clause 2 of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. Her lawyer's interview was crucial to her defense because she was arrested while trying to transport ashes out of the nation. However, the interview was unable to proceed because of the process as outlined under Section 3, subsection B, clause 1, requiring prior appointment. The petitioner argued that because these clauses in the Act were arbitrary and irrational as they violated the provisions of Article 14 of the Indian Constitution relating to right to equality and Article 21 of the Constitution of India relating to right to life and personal liberty. So, the issues concerning the very judgment relating to the section, in particularly section 3 of Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, also pertaining to Article 14 right to equality and Article 21 right to life and liberty. Also, Article 22 of the Arrest and Preventive Detention as per the provisions of Preventive Detention Act 1950. So, the very issues raised in this landmark judgment, is there a breach of Articles 14 and 21 of the Indian Constitution, and also as provided the subclauses 1 and 2 of Section 3, subsection B of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. Further, the question raised, that is relating to, is it possible that the petitioner's inability to seize legal counsel constitutes a violation of Article 22 of the Indian Constitution relating to preventive detention? So the petitioner's arguments that we would like to discuss. The petitioner claimed that it was discriminatorily and unjust to only permit one interview with family members each month. This relates to the time when under trial prisoners were granted the opportunity to interview a family member or friend twice a week as provided under Rule 559A, and convicted prisoners once a week under Rule 550 of the jail guidelines as outlined in the Punjab Jail Supervision and Management Manual. Further, the petitioner argued that also given a thorough explanation of Article 22 of the Constitution, which states that a person in custody may counsel the attorney of his or her choice to represent him. Further, she goes on to say that she was entitled to the opportunity to meet with the attorney of her choice under this provisions of the jail guidelines and manuals. Further requirements such as scheduling an interview in advance and having the customs officer present who has been nominated by the customs collector was unjust and arbitrary. Thus, it violates the constitutional provisions under Article 14 and Article 21. Further, here the respondent's arguments in this case that the authorities' restriction was fair, reasonable, and justiciable since Article 14 and 21 of the Indian Constitution were not violated, neither were subclauses 1 and 2 of Section 3, subsection B of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. In answer to the petition, the respondents stated that they had no objections if the petitioner was allowed to interview her sister and daughter twice a week, as is the situation with inmates awaiting trial in lieu of once a month, regarding her lawyer interview, they would not require the presence of an excise or customs officer during the interview. So now we would like to discuss the very judgment delivered in this important landmark judgment relating to Francis Coralie vs. Union of Territory of Delhi in 1981. So the Honorable Court concluded that Article 14 and 21 of the Indian Constitution are violated as per the provisions of subclauses 1 of Section 3, subsection B of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, which governs the petitioner's access to a consultation with the attorney of her choice. As a result, the clause must be declared unconstitutional and void. The court determines that it is reasonable for the petitioner to have the right to meet with his legal counsel at any reasonable time during the day, provided that the superintendent of the theatre shall grant the petitioner an appointment that is made as soon as possible. Further, the Honorable Court also stated that the interview does not always have to be conducted in the presence of a designated officer from the Customs, Central Excise, or Enforcement Directorate. However, if the officer's presence can be easily arranged at the time of the interview without requiring a postponement, then that officer may be present. If not, any other jail official may, if deemed necessary, observe the interview. However, they may not do so in a way that would place them in hearing distance from the detainee and the attorney. As a result, the Honorable Court granted the petitioner's relief and accepted the writ petition with the goal of giving exactly to implement the provisions as provided under Article 14 and Article 21 of the Constitution of India, and also regarding the very working of the provisions as provided under Article 22 of the Constitution relating to preventive detention, as Section 3, subsection A clause 1 and 2 are arbitrary and violating the provisions of the Constitution in case of, in particularly, the fundamental rights of the detainee, and that is Francis Coralie, as the very section, that is section 3 of the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, is arbitrary and violating the basic fundamental rights and human rights. Those are guaranteed under Part 3 of the Constitution of India.